Welcome everybody to October's Facebook Live Ask a Lawyer series here at Carr & Carr Attorneys. Today we're going to be speaking with Ryan Childress. He's the newest member to our firm, and he is going to discuss specializing Social Security disability claims. I want to welcome you aboard, Ryan, and if you would, before we get started, why don't you just tell us a little bit about yourself?
Sure. Well, hi everybody. I know we met, I think, in September, but I've been here about 2 months now.
Not 2 months. Yeah.
Everybody's great. I really like working here. As I explained before, I'm a Missouri transplant. I came to Oklahoma in 2009 for law school and stayed. I've handled personal injury cases, primarily Social Security cases, quite a few. And I came from the insurance defense world, and then I transitioned back to the plaintiff side, which I prefer. I think that's a better fit for me. And in my spare time, I really like CrossFit and tennis. So actually, I got my favorite cup here. I don't know if you can see, it's got tennis balls on it. So it's kind of fun.
That's great. And speaking of tennis, obviously, even though first day of fall was a couple of weeks ago, it actually now feels like fall, doesn't it?
Yeah. So, last night I was out at the courts and it was beautiful. It was actually chilly, which kind of blew me away. You know, it's so nice. And this weekend it's supposed to rain, right?
Yeah. So anyway, great weather to do outdoor things, and looking forward to that. But anyway, let's kind of get started, because what we're wanting to do is kind of help everyone in this segment, help everyone kind of understand what happens when you go to the hearing process and what to expect. So let's just start out, Ryan. If there is a hearing, who would be at that hearing?
Sure. I think that the reason we chose to talk about this topic, Rhett, is the hearing, in my opinion, is the most intimate part of the entire approval process, because that's where the client gets to tell his or her story to, you know, that Social Security gets to see their face, you know, gets to see who they are, gets to see who they are and why it is that they're saying they can't work. At a hearing, and it depends on the type of case you have. If you're an adult, then at the hearing there will be, of course, me, your attorney, or whoever your attorney might be, a court reporter who's taken down everything that's said. There's a transcript of the hearing, an administrative law judge, and also a vocational expert. And the vocational expert is there to testify about what kinds of jobs you potentially could do or done in the past and those sorts of things.
Okay, go ahead.
Oh, we want to talk about
what the roles are?
Oh, sure. So the first one that's probably what most people are looking at is the administrative law judge. That's sort of the face of Social Security, and it varies wildly what the administrative law judge will do based upon the particular judge. In Tulsa, we have quite a few different administrative law judges with very different personalities. Some of them are very involved and will ask you lots of questions about your daily routine and your physical or mental limitations. Some of them are very passive and will pass on the buck to me or whoever your attorney might be to question you. Your responsibility when you go in is to answer their questions truthfully and honestly. You will be under oath, so it's important that you tell the truth and just answer the questions that they have. None of them will be overly complicated or difficult, but it's very important that they get a lot of detail. Now, just keep in mind, in the back of your head, the number one question that everybody's trying to answer is, why can't you work?
Right.
So if you keep that in the back of your mind with everything they're asking you, that's really what they're trying to get at. In addition to the administrative law judge, there are other folks there who will play very important roles also. The court reporter takes down every word that's said, because there's a written transcript of the hearing in the event we need to file an appeal.
Okay.
And the vocational expert is there to testify about your past work history. He or she will use what's called the Dictionary of Occupational Titles, which I know that's a fancy phrase, but really all that is basically an encyclopedia of work. Every job that exists on the planet is somehow classified in this document, or in this book, excuse me. And the vocational expert will classify your past work history based on the exertional category it meets. There's 5. There's light, medium, sedentary, light, medium, heavy, and very heavy.
Okay.
And that just depends on how demanding physically the work is. They will also classify it based upon a specific vocational profile, which, and for lack of a better term, is how difficult is it on a 1 to 10 scale. For example, lawyers are a 7. So things that are a 10 would be like a NASA rocket scientist, those kinds of things. And then, clerical, janitorial type jobs, those are down in the 1 and 2 range.
Okay.
So that's kind of just an example of
The
that.
way they rank those?
Yes.
Okay.
And the vocational expert, in addition to talking about the work you've done in the past, will also answer hypothetical questions from the administrative law judge based upon your testimony. So the judge will ask the vocational expert to assume a person of a certain age with certain perhaps physical or mental limitations, and then ask, is there a job that person can do? And if the answer is yes, then it's up to your attorney to try to cross-examine the vocational expert to get the vocational expert to eventually testify that there's nothing that you can do.
Okay.
And sometimes the vocational expert will say right out of the gate, look, I don't think this person can work. There's no job I can think of that exists on the planet.
What their skill was and anything. Okay.
Right.
Sure.
And so that's the role of the vocational expert. Sometimes in adult cases, you will have a medical expert. And this usually comes up if you've got some type of really rare genetic disorder, perhaps a really odd form of cancer, something that the general population doesn't know a whole lot about. And so Social Security may send you to that doctor to be examined, or they may call the doctor live at a subsequent hearing and ask the medical expert to explain your medical condition, what kinds of treatment you would need, the types of workplace accommodations you might have to have. And then the administrative law judge will then render a decision.
Okay.
In a kid's case, for minors, so children under age 18, there are no, at the hearing, there's no vocational expert because they're not concerned with your work history. It's all about your medical conditions. They may send a questionnaire to your teacher to ask your teacher to fill out some questions about you. And they may ask the teacher to come testify. That's well within the judge's power, or to send some kind of written statement on the child's behalf. And there could be a medical expert at a child's hearing, again, depending on the type of medical conditions that they do have.
Okay.
So that kind of covers who's at the hearing and why it is what they're.
Okay. So you're at this hearing. In most instances, is there a decision rendered? And if not, is there the potential there could be a second hearing, and what would be the circumstances of that?
Sure. Yeah, there can be second hearings. Usually the circumstances that give rise to a second hearing are, let's say, for example, that the judge has some questions that they want a doctor to answer. Right. So they may send what we call interrogatories, which are just very fancily worded questions to a medical expert. There may be a need for that expert to testify, and if that's the case, there will be a subsequent hearing.
Okay.
There could also be a subsequent hearing if you are denied and we appeal, and the appeals council, which is the next step after a hearing, agrees with us, and then they remand the case back to the administrative law judge for further decision making. I've actually had a couple of those happen, so that could be an example of when there's another hearing. So.
Good. So, and you kind of brought it up there on the denial, but what in a hearing, what are the potential decisions that are made? Sure.
There are three, well, I guess technically there's four, and the fourth would be, is there a need for a second hearing? Okay. But assuming there's no second hearing and the judge is ready to decide your case, there are three possible decisions. The first is a fully favorable decision, and that's the decision everybody wants. A fully favorable decision means the judge bought your story, believes you cannot work, you are entitled to back pay, and they agree that you became disabled on the very date you said in your application that you were disabled. That's the goal that we try to strive for, because that's just the best possible outcome for a client. Okay. The second is still a good outcome, although it's not as ideal as a fully favorable. It's called a partially favorable decision. And in a partially favorable decision, what you're looking at is, yes, Social Security agrees you can't work, but they found you disabled on a date other than the date you say you became disabled. Okay. So, for example, if let's say you said, well, I slipped and fell and that's my backup, but you didn't get an MRI till 6 months later. Well, the judge might say, well, okay, we know the date of the MRI because it's a record that you submitted, so we're going to find you disabled, but we're going to find you disabled at the date of the MRI, not the date you say you fell 6 months ago.
Okay.
So you're still disabled, you're still entitled to benefits, and you still get some back pay. It's just not as ideal as a fully favorable.
That limits the, because they couldn't actually determine, since there's no record of when you were actually hurt.
That's correct.
Other than your word. Okay.
And then the third and final decision is what's called an unfavorable, and that's the one nobody wants. That means the judge denied your application, says you can work, you're not medically disabled, and you're not entitled to benefits. And that's the kind of the bummer decision. That's the one we didn't want.
Okay. And is there any recourse if you obtain that result as far as denied or? as you put it, that not a favorable decision.
Sure. Yeah, if you get denied, then the next step is you have 60 days from the date of the denial to file an appeal with the Appeals Council. The Appeals Council is an internal body within the Social Security Administration that reviews unfavorable decisions for errors of law. So, for example, let's say that the judge failed to consider some medical records in his or her decision, or maybe there was a need for a medical expert and the judge just didn't obtain one. We will submit, usually I think it's a 3 to 5 page appeal that's kind of worded like a strongly worded letter to the Appeals Council, enclosing your transcript and what's called your ERE, your entire record for Social Security, and ask them to take a look at it. The Appeals Council can then either grant your appeal and then remand the case back to the judge for further decision making, or they can deny your appeal. If the Appeals Council denies your appeal and we still feel that Social Security is getting it wrong, we can file a lawsuit in federal court in the district that has jurisdiction over your hearing office. So if you're in the greater Tulsa area, that'd be the Northern District of Oklahoma. If you're in Oklahoma City, that'd be the Western District. If you're in Muskogee, those parts, that's the Eastern District. And if we file that appeal and we are successful, then what the judge does, 2 things happen that are very important. The first one is the $6,000 cap on our attorney's fee is lifted, meaning we are then entitled to just 25% of your back pay, whatever that number might be. And second, a federal judge will issue a ruling that then sends the case back to the administrative law judge who heard your case to follow whatever that judge's recommendations are concerning the case.
To rehear the case.
Yes, or to address
the,
whatever legal or medical issue that wasn't addressed in the initial decision. Okay. So we actually represented a client once. This is one of the more meaningful cases that I've ever had. He was a 28-year-old man at the time of his hearing who unfortunately had a very rare form of genetic gastrointestinal cancer that basically ate his entire intestinal system. I think he had 10% of his intestines left. So for him to use the restroom was a very involved process because he had a J pouch that was inserted into his rectum, and that's how he was able to use the restroom. Well, during his first hearing, he asked to be excused because he thought he had to go to the restroom, and it was uncontrollable.
Right.
So he stepped out for about 10 minutes, and he didn't go through the whole process. He just applied some ointment to help him be more comfortable. But when he came back in, the administrative law judge said, okay, earlier you said an hour, you've only gone 10 minutes. You're not credible. I'm denying your case.
Just based on that.
Just based on that.
One thing. Okay.
So we filed an appeal with the Appeals Council, and the entire appeal was his testimony that said, look, Appeals Council, this gentleman did not use the restroom as he had testified to. He merely applied some ointment. Those are 2 fundamentally separate things. And the Appeals Council thankfully agreed with us and sent the case back and had the judge rehear it and address that specific issue. And after that second hearing, we got a fully favorable decision. So sometimes those things can happen, and it is very frustrating, but you just got to keep your foot on the gas, for lack of a better term, to make sure that the client gets their true story heard.
Okay. Like when you have these hearings, can you just ballpark or as far as success rate, how often, or is it just based case by case? Or
yeah, it's really a case by case, and honestly, a lot of it comes down to, in my experience, it comes down to the facts. What's going on medically with the person. It also comes down to the quality of the legal assistance in obtaining the medical records, because sometimes these providers are very difficult to work with. And if you don't have good legal assistance going out there and really harping on these providers to get the record, because if you get to a hearing and you don't have all the medical records in, some judges, they either won't hear the case or they won't view the additional medical. Okay. And so it's very important that you stay on top of those providers to get all of the treatment records from the client that are available.
Okay.
And the other thing I think that's important is the client's credibility. I once represented a man who had some very severe issues with his dominant hand, but he showed up to the hearing intoxicated.
Okay.
And so the judge wouldn't take testimony from him because he was medically impaired.
Right.
And so we had to present his spouse, who was not ready to testify, who we had not prepared for the hearing, and that case did not go well, as you can probably imagine. So a lot of it, I understand the gentleman was very nervous, and so he had a couple of drinks to calm him down, but it quickly I mean,
dominoed from there.
it quickly went bad.
Yeah.
And I think he testified he had something like 13 beers
that
morning, and his hearing was at 9 a.m.
Yeah.
And so it was just, it was not a good day.
So, but as we do with all our other type of cases, though, you're going to prep a client going into these. They're going to understand what they're going to be. Questions are asked, what to expect, so they'll go in and should have a good understanding.
Absolutely.
Yeah.
And that's not just me. Every Social Security attorney that I know, the good ones, they all meet with their clients in advance. They tell them, because when we get the notice of hearing from the local hearing office, it tells us the date and time of the hearing. It also tells us who the administrative law judge will be. And that's very important, because knowing these judges, what they like, what they don't like, we can in advance tell the clients, hey, look, this judge, for example, there was a judge on the bench at one point who had diabetes. Okay. And so a lot of folks will call us and say they have unmanageable diabetes. Well, if we go in front of that judge with unmanageable diabetes, it's a hard case to win, because he manages his, even though it's pretty bad. Right. There's also another judge in Tulsa who is a military veteran. So if we have a veteran that calls us and we get him on the hearing side, that's usually a good start, because the initial camaraderie between the administrative law judge and the client circles around their military service. Okay. And so that's also, that can also be
advantageous to the case.
Yes, sir.
Okay. Anything else you can think about the hearing process, or anything that you would like to share with our audience?
No, I can't think of anything. My suggestion to anyone who gets to a hearing is just listen to your attorney and relax, because really it's not a Law and Order season finale. Nobody's trying to, nobody's trying to trick you or anything like that. They just want to ask you why it is you can't work. Right. And so your responsibility is to, and you don't have to go buy a suit or a fancy dress or anything. Right. Just make sure that you've cleaned up the best you can, that you show up in maybe a pair of nice pants, and if you're a guy, maybe a button-up shirt. Just make sure you look like you're going to a job interview.
Presentable.
Absolutely.
Yeah,
and that will go a long way with the administrative law judges. I once represented a client who we told her to dress up or to dress nice, and she showed up in gym shorts and a hoodie. Okay. And the judge was very taken back by that. And so it's very important that, number one, you look presentable, and number two, listen to the advice of your lawyer. I've had clients in the past who they probably should have represented themselves, because they certainly didn't listen to what I had to say. Right. And it's very hard for me or any advocate to, quote unquote, win a case when you've got a client that's not listening to you. So choose your attorney wisely, pick someone who you respect, who you will listen to, because they've been through the process hundreds of times. Right. And chances are this is probably your first rodeo.
Yeah, and I agree. That's what as you say, go in, listen to your attorney, answer only the questions asked. I'm sure you don't want, like you said, some of them want to go off and tell a long story. And
and Rhett, that brings up a great point. So many people, and I understand it, because this is the first time that a client has had the chance to tell his or her story in person. But some folks, they want to, and it's kind of like walking through a minefield. The more steps you take, the bigger chances there are
to step on some. Yeah,
absolutely. And so try to, for example, what color is the sky? Blue. What color shirt am I wearing? Well, it's blue and red. You don't want to go on and give some long-winded narrative about your uncle's barbecue or your cousin's dog or something like that, because I've had clients do that, and then at the end they end up saying something that they shouldn't have said, and their case gets denied. Right. So you really just want, it's kind of like get in and get out. The less is best. Keep your answers short, sweet, and to the point, and just provide the details that the judge needs to know. And your attorney can help you with that.
Well, I know just sitting next to you, we often, next to each other, you're starting to get a lot of calls. We're getting a lot of people. Some we can help, some you can't. Right. You all may have covered this in a prior one. Are there, things that, would qualify people to get Social Security? And/or I've actually heard you try to help people, make suggestions. You realize it's not a case that would apply, but you're giving them advice on maybe what they could do to find employment in life.
Sure.
Things like that.
Yeah, I had a lady actually call me this morning she was 41 years old. She had a bad back, and she was just having a hard time finding work. And so I always have a hypothetical I use with folks who I kind of get the impression they really don't want to go through the process. They really just want to work, but they're having a hard time finding a job. I always say, okay, let's assume that my law firm is hiring. for like a position where you would take calls, maybe copy documents and put them in hard files.
Okay.
And I say, why can't you do that job? And this lady this morning said, boy, that'd be great. I'd love to do that job.
Yeah.
And so I said, I just encourage you to apply at law firms, because I think they're pretty accommodating places to work, and you can stand up, sit down, those kinds of things. Because some jobs, you just can't do that. Maybe you're on an assembly line and you got to stand for long periods of time or something like that. So there are some pretty accommodating jobs out there. It's just sometimes folks don't think outside the box.
Right.
And so I try to, if I get the impression, a lot of people tell me I'm a really hard worker, work my whole life. If I start to hear those kinds of things, then I try to counsel them away from Social Security and maybe do a more accommodating job.
Yeah. Instead of just saying, no, I can't help you.
Yeah.
And you don't have a case, and and the phone conversation's ended, you go that a little bit further and try to help these people find an alternative to work.
Right. I mean, and that's really why we're here. And plus, it's no service to them for us to take their case, get to a hearing, and lose, because they could have been working this whole time.
Right.
And they're going to go through financial hardships to get to that point. And it's like it would be better if they just had a regular paycheck coming in. I mean, I think we could all agree with that.
Yeah. Agree. Okay. Any other things you'd like to add to the conversation?
No, I think that pretty much covers it. If there's anything we can do to help you, feel free to give us a call. We're here 8:30 to 5:30 Monday through Friday. I would just encourage you to, if you're considering going through the Social Security process, to give us a call, and we'd be happy to see if there's something we can do to help you.
That's 918-747-1000, or you can go on the internet, carr.com. We have a lot of information on there, not just Social Security, but all the types of cases we handle, and we'd be glad to listen to you, see if there's something we can do for you. So give us a call. And I guess that's it for this month. November 1st will be coming up sooner than we think, and everybody enjoy and have a great weekend.
Bye-bye.